होने वाला है, बस ठीक है। Law of gifts, effect on non-registration improper stamp duty is an aspect wherever one speaks of gifts, etc. The interplay between the factum of the non-registration and improper stamp duty is an aspect wherein not only lawyers but people at large wish to discuss about it. Therefore, today's session, Mr. Ameet Kumar Deshpande, a senior advocate, will take us to the insights in this respect of the interesting topic of law of gifts, effect of non-registration, and improper stamp duty. Over to you, Ameet.
Good evening, everyone. Though a small part of law, gifts, especially with reference to the impact or effect of the non-registration of the instrument of gift and the deficit stamp duty paid on such document, is a very important aspect of law, which we all need to know properly. Those of us practicing in the trial side and also on the appellate side are often confronted with not just questions, but conundrums of what would be the impact and how shall we take the matter further when we are confronted with objections for the admissibility of the very genesis of one's case. Most of the times where suits are filed or are objected to, the right that a party asserts is based upon a document of title. Gift is one of the documents of title and is essentially a part of the Transfer of Property Act and the principles under various personal laws as affected by the statutes. Therefore, we shall now understand in brief the requirements, the definition, the essential ingredients of the gift, of the transfer of property under gifts, the method and the manner in which gifts are to be given effect to, and allied topics. Let us start with the definition of gift as given under the Transfer of Property Act. Section 122 of the Transfer of Property Act 1882 defines gift. There are several other sections under the enactment which throw some light on the finer aspects of this transaction. I will read out to all of you Section 122 of the Transfer of Property Act 1882, which you all can see on the screen. Gift is the transfer of certain existing movable or immovable property made voluntarily and without consideration by one person called the donor to another called the donee and accepted by or on behalf of the donee. Acceptance when to be made? Such acceptance must be made during the lifetime of the donor and while he is still capable of giving. If the donee dies before acceptance, the gift is void. Section 122, if deciphered, we would understand what are the essentials of the transaction of gift under the Transfer of Property Act. These are the most essential requirements. That is the person making the gift, then the person receiving or accepting the gift, subject matter of the gift, the transfer of property under a gift must, like in any other transfer of property, must be a voluntary transfer. When we are saying and speaking about voluntary transfer, we also need to know and understand the Indian Contract Act, the essential requisites for making a contract valid. I need not delve deep into those requirements. All of you know that for an agreement to be a contract, an agreement to be valid, there has to be consent, free consent. There should not be any coercion. There should not be fraud. There should not be misrepresentation. There should not be mistake of law. And there should not be lack of consideration. However, when it comes to the transaction or transfer of property under a gift, the lack of consideration will not invalidate the gift as such. However, what kind of consideration is permissible for a gift is what I will explain a little later. Now, as I have stated, the person who is to gift the property is an essential part of this transaction. The person who is receiving is essential. The subject matter is essential. The subject matter of a gift will be either a movable property or an immovable property. Then what is very important in this is, apart from the absence of consideration amount in a gift, the gift has to be accepted and it has to be accepted by the donee, and it has to be accepted when the donor is alive and is still capable of giving. Without acceptance of the gift, the document of gift will not effect a transfer of property from the person donating the property in favor of the person who is receiving. The other essentials of a valid gift are that the document evidencing the gift, evidencing the transfer of property by way of a gift, must be engrossed or written on sufficient and appropriate prescribed stamp duty. The stamp duty, the amount of stamp duty is prescribed under the Indian Stamp Act or under various state stamp acts or under the Indian Stamp Act where there are state amendments made to the territorial limits of a particular state. So for the purpose of knowing as to what is the appropriate and prescribed stamp duty for a gift, one has to not only refer to the state stamp act if it is separately enacted by a particular state, or has to rely upon the provisions of the Indian Stamp Act and also have to see the state amendments made to the Indian Stamp Act. Now, mere payment of stamp duty is not sufficient. It is very, very essential for all of us to understand and remember that the payment of stamp duty is a distinct mandate under law from the requirement of registering the document under the Registration Act. So the two essentials are the gift deed has to be engrossed on sufficiently paid stamp duty, and that document has to be registered also. The next of the requirements are the document of gift must be signed by or on behalf of the donor. The document of gift must be attested by at least 2 witnesses. Friends, we have to remember the emphasis supplied in this to the word attested. Mere signing the document by two or more witnesses is not sufficient, but those 2 persons have to sign as attesters. There is a definite connotation to the word attestation as defined and described under Section 3 of the Transfer of Property Act. The act of attestation is a conscious signing of the document by the witness who is in fact indicating that the executant of the document has signed the document and this witness has seen the voluntary action of the executant of the document. It is possible that the scribe of a document can also be an attester. However, merely signing it as a scribe would not be sufficient. There has to be the intention on the part of the scribe and on the part of the witness to sign the document as an attester. So this is an essential requirement which most of us would sometimes fail to remember when verifying the document of gift whenever parties rely upon in the suits or in proceedings before the court. Wherever the subject matter of the gift is immovable property, it is mandatory that it must be effected by only a registered document. There is only one exception under the Transfer of Property Act, which I will come back to in another moment. In the case of movable property, the gift can be either by executing a registered document, which should again be signed by or on behalf of the donor, or it can be simply by delivery of the movable property to the donee. And the delivery has to be as in the same way as in the Sale of Goods Act, or as like goods sold which could be delivered. The exception for registration of a gift deed pertaining to immovable property is engrafted under Section 129 of the Transfer of Property Act. Section 129 speaks of 2 exceptions. One exception is when the movable gift is made relating to movable property in contemplation of death. That is called donations mortis causa. However, another important and more often forthcoming exception is that the requirement of registration, signing the document, attestation of that document is given an exception in the case of Mohammedan law, where the parties are governed by the personal Mohammedan law, then these requirements are not essential. So what are the essentials when of gift? When there is a gift between or among persons following the Mohammedan law is something which we will relate to a little later. Now, it is also very important for us to understand that once a gift is executed validly, properly, as per by complying all the requirements under the Transfer of Property Act, under the relevant Stamp Act, and the Registration Act, then whether such a gift can be revoked or not, if it can be revoked under what circumstances, and at what point of time. Once the gift is validly accepted as required under the provisions of the Act, even after the delivery of the deed of gift and before registration, the donor can revoke the gift. In fact, cannot revoke the gift. That is, once the deed is written and the gift is accepted, but the written document is yet to be registered. For instance, where the document is given to the registering authority or officer, and the registering authority or officer for some reason has kept the document pending registration. Just because it is pending registration, the donor will not get the right to revoke the gift, as the donor has validly executed the gift and the donee has accepted such a gift. The exception will be if there is no acceptance of the gift, then registration does not make the gift irrevocable. That is, we can now remember here the emphasis is on acceptance. So the finality is about the acceptance of the gift by the donee, and registration is only a requirement under law which would not affect the transfer of property as such, qua the donor and the donee. However, the law requires registration also, but merely because it is registered, if the acceptance is not forthcoming, then that will still affect the transfer. The essentials under the personal Mohammedan law, essentials of gift, are that the donor has to declare that he is donating or gifting the property or the subject matter of the gift. After the declaration, the gift has to be accepted by the donee, and mere declaration and acceptance is not sufficient, but delivery of the property is mandatory. These three essential requirements have been enumerated in various decisions of the High Courts and the Honorable Supreme Court. The requirement of executing the document to effect the transfer under the gift under the Mohammedan law is not mandatory, and therefore there is no question of registration of such a document of gift. And as a corollary, it has been understood widely that there would be no requirement of payment of stamp duty also on such a document which is merely evidencing or is merely a written record or a memorandum of the act of declaration, acceptance, and delivery of the gift under the Mohammedan law. A specific terminology is used to describe such gift under the Mohammedan law, and that is called hiba. There were decisions of different courts, the High Court of Andhra Pradesh, the High Court of Calcutta, had in earlier days held that though under the Mohammedan law, a hiba can be made by delivery of the property to the donee by declaring the gift and the acceptance of such gift by the donee. But if the said transaction of hiba is recorded in a document, then relying upon Section 17 of the Registration Act, few high courts then had held that such a document would require either stamp duty or would require registration. However, the Honorable Supreme Court, in a subsequent decision, has ultimately held that there is no mandate of writing a document to effect the transfer of property under the hiba, and therefore the non-registration of such a memorandum of gift or such gift deed would not affect the transfer of property under hiba. Under the Hindu law, the requirements or the essentials of gift as enshrined and enumerated under the Transfer of Property Act remain the same. Now, there will be peculiar questions arising in peculiar situations in cases where the mother and daughter, say for example, stay together in a house, and the mother has the intention of giving this property, the house itself, to the daughter. And there is a possibility that in spite of the hiba or the gift executed by the mother in favor of the daughter, who are governed by the Mohammedan personal law, the mother may not move out of the house after the hiba. In such circumstances, how to understand this requirement of delivery of the property? It has been held in different circumstances that the delivery has to be actual delivery or actual physical handing over of the property by the donor in favor of the donee. And only when there is actual physical transfer of the property from the donor to the donee, that third requirement under the hiba is fulfilled. However, in a case which of the kind which I have just now narrated, the actual and physical delivery of property by giving the whole control of the property in favor of the donee and detaching the complete control over the property by the donor is not possible and is not seen, is not visible. Therefore, in such circumstances, there are certain judgments which have stated that if the daughter continues to retain the possession or the custody, or she continues to stay in the house after the hiba, that would be one indication to show that the delivery of the property has been made by the donor in favor of the donee. Various different circumstances will arise in different cases, but the essential three requirements are the grand norm, which we must remember, and the facts and circumstances of different situations can be analyzed and can be narrated appropriately to assist the court in arriving at proper adjudication of the cases. What happens if the gift is a conditional gift? I had just now said that a gift validly executed once becomes final and is irrevocable. The donor definitely will not have the right to unilaterally revoke the gift for whatever purposes, for whatever reasons, or for whatever causes, except on the ground that the gift was not validly executed and is hit by any of the provisions which invalidate a contract under the Contract Act, but not for the reason that it is not for consideration of some money or amount. So if the gift is an outcome of fraud, misrepresentation, without free will, consent, in such circumstances, of course, the donor can seek for revocation of the document. But in all other circumstances, once the gift is absolutely made, it becomes irrevocable. I am now at a situation where if it is a conditional gift, what would be the position of law? One can rely upon the provisions of the Transfer of Property Act itself, which will describe such situations. And it says, if both parties agree that on the happening of any specified event, the gift shall be revoked, then it is permissible to revoke such a gift. However, the happening of such an event should not depend on the will of the donor. So in any event, please remember, the donor should not hold the control to revoke the will at his will. But it could be, both the parties could agree upon the fact that on the happening of a particular event, the gift can be revoked. If the revocation is agreed to be at the will of the donor, then such agreement is invalid and therefore the gift is void. Once an absolute gift is made, the condition attached to the gift restricting an alienation shall be void. That is, if the gift is validly executed, but a condition is imposed that the donee shall not have the entitlement to alienate the property or shall not have the right to enjoy the property, then such a condition becomes void and not the gift. However, like all rules have exceptions. While reading section 122, 123 and 129 of the Transfer of Property Act, we must also read section 31 and section 32 of the Transfer of Property Act in this context, where section 31 refers to a condition superadded to to a transfer of property. So, in cases where a gift is executed with a condition subsequent superadded to the gift, then if there is failure to accomplish such valid condition subsequent, the gift would revert back to the donor. There are umpteen number of cases which deal with situations where there is a condition subsequent superadded to the gift, and the courts have construed the document to know the exact nature of the condition superadded, and then have described whether such a condition would actually affect the gift or not. The condition subsequent which is superadded to the gift must not be either illegal, immoral, or must not be an impossible condition. In such event, it's not the gift which gets revoked, but such a condition becomes void and the gift will stand to be valid. What happens when several things are transferred in one transaction of gift to one person, and one of such things is burdened with an obligation? This is described under the Transfer of Property Act, this situation, and it is said that when several things are transferred in one form and one of them is burdened by an obligation, then the gift has to be accepted along with the obligation attached to it. If there are two or more separate and independent transfers of several things, and one of such things is burdened by obligation, then the person receiving the gift has the choice to either refuse that thing which is burdened with an obligation and to accept the other thing, not burdened with the obligation. So in such circumstances where there are independent transfers of two or more things, if one thing is accepted, the gift is valid to that extent. If the other thing which is burdened with an obligation is not accepted, then the gift will not be given effect to insofar as that other part is concerned. I had referred to the Contract Act. However, I had not stated that the person receiving the gift has to be competent to enter into a contract as required under the Contract Act. But like a minor, if he is a person who is not competent to contract when he accepts a gift, and if the gift is attached with a burden of an obligation on the person receiving, then a minor in such a case need not or is not bound to accept the gift with such obligation. So the gift will be whenever if a minor is accepting the gift which is burdened with an obligation, then the gift will still be valid and no burden of the obligation would be cast on the minor. But if the minor, after attaining the majority, or if a person who was otherwise not competent becomes competent later on, and if he is aware of such an obligation which was attached to the gift, and after being aware, if he chooses to hold the property, then such person becomes bound by the obligation also. The two essential requirements of the whole transaction of the transfer of property by way of gift, as far as the practicing advocates are concerned, are stamp duty and registration. Now, the relevant provisions of the Registration Act, which come into play in our everyday practice, are sections 17, section 18, and section 49 of the Registration Act. I'm not saying that the other provisions are not relevant or important, but in this short duration, what is more important is section 17, 18, and 49. Section 17 deals with a list of those documents which are required to be mandatorily, compulsorily registered under law. Section 17, subsection 2 is an exception in certain circumstances as to when those transactions which are listed in subsection 1 would not be required to be mandatorily registered. So subsection 1 would say that the instrument of gift, section 17(1)(a) says instruments of gift of immovable property is a document, are documents which are registered, which are compulsorily registrable. Subsection 2 speaks about what are those documents which need not be mandatorily when this subsection 1 is not applicable. You can all have a glance at the entire provision to understand what are all the documents that require registration mandatorily and what are an exception under what circumstances. Section 18 deals with those documents of which registration is optional. Now, Section 49 of the Act says the effect of non-registration of the documents required to be registered. Now, it reads no document required by Section 17 or by any provision of the Transfer of Property Act to be registered shall affect any immovable property comprised therein, or confer any power to adopt or to be received as evidence of any transaction affecting such property or conferring such power unless it has been registered. I will read this part of the section once again. It says no document required by law, no document required by section 17 or by any provision of the Transfer of Property Act to be registered shall be received as evidence of any transaction affecting such property or conferring such power unless it has been registered. So the plain reading of this part of the provision says that if a document is not registered, then such document shall not be received as evidence of any transaction affecting such property. Now there is a proviso, provided that an unregistered document affecting immovable property and required by this Act or the Transfer of Property Act to be registered may be received as evidence of a contract in a suit for specific performance under Chapter 2 of the Specific Relief Act 1877 or as evidence of any collateral transaction not required to be effected by registered instrument. Please mark these words. Firstly, the provision says, as a matter of rule, that if a document which is required by section 17 or by the Transfer of Property Act to be registered, it shall not be received in evidence unless it has been registered. Secondly, however, still such document which is not registered can be received as evidence only in two circumstances. One circumstance is it can be received as evidence of a contract in a suit for specific performance. For example, a person has executed a document and he wants to rely upon that document in a suit for specific performance. Then, even if such a document requires registration, if it is not registered, still that document can be looked into. And a document which is required to be registered, when not registered, also can be received as evidence. For what purpose? For any collateral transaction. That transaction which is collateral, and that collateral transaction is something which is not required to be effected by a registered instrument. For example, a document may contain a transaction which essentially affects the transfer of property and also another transaction which independently would not require registration at all. If I may quote an example, a document which says that a person A has received an amount of rupees 10,000 from person B and he promises to repay that amount of rupees 10,000 within 3 months. And further, the document says that to secure such a loan, the person who has received the loan is giving as a security certain immovable property which is more worth rupees 100 and above. The part of the document which deals with the transaction of securing the loan by mortgaging the immobile property worth rupees 100 and more requires mandatory registration under the Registration Act as well as under the Transfer of Property Act. And therefore, that document cannot be looked into, cannot be received in evidence to know whether that document affects the transaction relating to the property under subsection 1 of 49. But the very same document can be received as evidence for the purpose of ascertaining whether there was a relationship between A and B of the person who is giving the loan and receiving the loan or not. For the purpose of establishing such a jural relationship between two persons under the document can still be looked into. Because to create such a jural relationship, there is no registration required. And that is how the proviso has to be understood. Now, under section 123 of the Transfer of Property Act, the gift is mandatorily required to be signed, attested, written on an instrument. Only then it becomes a gift which could transfer the property, and therefore it also requires mandatory registration. Then can a gift be produced before the court and received as evidence? It cannot be received as evidence for the purpose of ascertaining one's right over the property on the basis of the transfer under the gift. If the said document is to be relied upon only for the purpose of some collateral transaction, which does not require registration at all, then this document could be looked into. Now, what could be the collateral transaction so far as a document of gift is concerned? As I said, it can be to establish the right of a person in possession and the nature of such person's possession over the property. Assuming that a suit is filed for eviction of a person from the property on the ground that he is only a licensee or a lessee, and the person defending the suit wants to rely upon this unregistered document only to show that the jural relationship between the plaintiff and the defendant is not that of the licensee or the lessor and lessee, but is something else, and that the possession of the person defending the suit is not in the nature of license or lease, the document could possibly be looked into. This exception is very essential to be taken note of by all the advocates, all practicing advocates, so that we don't miss out on the impact of such unregistered documents. Now, the requirement of payment of stamp duty. Friends, we all need to understand that the Stamp Act imposes the liability to pay stamp duty on particular instrument. Majorly, the liability is imposed on the person who is receiving the benefit under that document. So the executant of the document is sometimes made to pay the stamp duty. Sometimes the beneficiary is made to, or the person who is getting the document executed is made liable to pay the stamp duty. So the relevant provisions of the Indian Stamp Act and the respective state acts have to be looked into, and the nature of the document that is in question has to be looked into to ascertain who is liable to pay the stamp duty. One has to understand that the stamp duty, the amount of stamp duty that is required to be paid, is also different under the Indian Stamp Act and under the various state amendments or under the various state stamp acts, and is also different for different persons who are executing the gifts. For example, if the gift of an immovable property is made by a person in favor of his spouse or children, then the stamp duty leviable on such a document is generally lesser than the stamp duty which is payable on a gift between two different persons who are not related in this manner. So the Stamp Act has a schedule which enlists the nature of the instrument, the nature of the transaction of the document, and the actual amount of stamp duty that is required to be paid, and the conditions under which the amount of stamp duty varies. Generally, it is the valuation of the property that is taken into consideration for the purpose of levying the exact amount of stamp duty on the document. Now, the Honorable Supreme Court has clarified certain aspects of law. Firstly, we need to understand why is Stamp Act enacted. And the Supreme Court has said in many cases that the object of Stamp Act is to secure revenue for the state. It has held that the Stamp Act is a fiscal measure and is not enacted to arm the litigant with a weapon of technicality to meet the case of his opponent. Stamp Act imposes the liability to pay appropriate stamp duty on instruments as prescribed. If the proper stamp duty is not paid, then the authorities enumerated under the respective stamp acts are entitled, subject to certain exceptions under the act, to recover the stamp duty from the persons who are primarily liable to pay the stamp duty. Now, an insufficiently or improperly paid document, paid document, just because the stamp duty is not properly paid or is insufficiently paid, the transaction recorded under the document may not be essentially affected by such improper payment of stamp duty. The only consequence, or rather the major consequence of improper and insufficient payment is that that person will be liable to pay the appropriate stamp duty and would also be liable for penalty. If a person had mistakenly failed to pay the appropriate stamp duty and not a person who has designedly and voluntarily made efforts to ensure that he wants to evade payment of stamp duty, but a person who has mistakenly failed to pay the appropriate stamp duty, he has the right to, or a choice under the act itself, to make good the deficit stamp duty by placing the document before the appropriate authority under the act, who would determine what is the actual stamp duty to be paid, and he would be entitled to make good the deficit. So it is not that even if a person has mistakenly or unknowingly escaped the actual payment of the proper stamp duty, that he will be always penalized, but he has an option. If he goes within the prescribed time before the authority, he can still make good that stamp duty. The authorities have the right to recover the deficit, stamp duty, and the penalty as prescribed under the law in all other circumstances where the document is not sufficiently stamped or is totally not stamped. Now, there is a duty cast on the court whenever an improperly or insufficiently stamped document or an unstamped document which is required to be stamped under the law, whenever such a document is produced before the court as evidence, then the court is bound to impound such document until the proper stamp duty is collected and the penalty thereon is also levied and collected. Now, when an insufficiently stamped document comes before the court as evidence, there are decisions which say that mandatorily the court has to impound the document and determine the duty payable on such a document, and then compel the person producing the document to pay the deficit stamp duty and also levy the 10 times penalty thereon. But there are decisions which have now held that the court has to refer the document to the appropriate authority under the Stamp Act for determining the correct stamp duty payable on the document. However, what has been emphatically stated is that it is the duty of the court to apply its mind before admitting any document on record, which when such a document which is required to be paid with sufficient stamp duty is not adequately stamped. And the court, if it mistakenly simply marks the document as an exhibit, that would not be sufficient to say that there was any application of mind by the court and that the court has admitted such document on record. The provisions of the Stamp Act also clearly say that once the document is admitted in evidence, especially if it is admitted without any objection from the opponent, then the court has no authority to question the admissibility of the said document on the ground of insufficiency of the stamp duty. Therefore, in this context, it becomes very important to note as to whether a document tendered as evidence which is not sufficiently or adequately stamped has been simply taken note of by the court or has been admitted exhibiting any application of mind. If there is no application of mind, then this rule that a document once admitted cannot be then objected to will have to be seen with little more circumspection. I had earlier also stated that just because a document requires stamp duty and is adequately stamped does not become admissible in evidence for all purposes if such a document is required to be registered also and is not registered. The only exception, so far as the non-registration is concerned, are the ones which I have narrated, which are stated in the proviso to Section 49 of the Registration Act. But when the adequate stamp duty is not paid, then the Stamp Act mandates that the document cannot be looked into or relied upon or cannot be admitted as evidence by the court for any purpose. And therefore, the effect of non-registration of a document and the effect of non-payment of the adequate stamp duty upon a document are two distinct factors that affect the document and its admissibility in the court as evidence. If the document is not registered, the proviso to Section 49 of the Registration Act will come into play. If the document is not adequately stamped, then the duty of the court is to impound the document and thereafter to refer it to the appropriate authority for determining the appropriate stamp duty and to recover the same. However, there have been instances where the document was once produced in one litigation, it has been impounded once in that litigation, the adequate stamp duty and penalty thereon has been recovered. And now after several years, if the same document is to be relied upon in another litigation, then the court need not and in fact cannot impound that document once again, nor can it levy and recover the so-called deficit, stamp duty, and penalty thereon. Very few judgments I have referred, I've enlisted. All of you can just note these judgments. Right from the case of Javer Chand versus Pukhraj Surana, reported in AIR 1961, Supreme Court 1655, where the question was about interpretation of the provisions of the Stamp Act, where the court had exhibited the document, marked as an exhibit. The court had marked as an exhibit the document, and it was admitted in evidence. The Supreme Court interpreted the relevant provisions and held that once the document is admitted, then it cannot be objected to once again. That question cannot be reopened. The question there also was whether marking the document as an exhibit is in itself admitting the document in evidence, or it is only a ministerial act to identify the document and would not amount to application of mind by the court to ascertain the correctness of the stamp duty paid on the document. From there, the judgment in the case of Shamal Kumar Roy versus Sushil Kumar Agarwal, reported in the case of 2006-11, volume 11, SCC page 331, where the court emphatically explained the distinction between the requirement and the impact under the Registration Act and the relevant Stamp Act. When a sale deed or a gift deed or any other document which requires registration mandatorily and also requires the stamp duty to be paid, if there is deficit in either of the two, what is the impact and consequence of that has been explained in this judgment very adequately and properly. The judgment in the case of Phulpatti and another versus Ram Singh, reported in 2015, volume 3, SCC page 164, deals with two judgments of the Honorable Supreme Court which seem to be giving two different opinions on this aspect of law, and this judgment has clarified the position of law. A recent decision in the case of Sita Rama Shetty versus Monappa Shetty. The neutral citation is 2024 INSC 650. Deals with the impact of improper or insufficiently paid stamp duty on a document and the duty and authority of the court to impound the document and recover not only the deficit stamp duty but also 10 times the penalty or lesser amount of penalty, whether that discretion is available with the court or not, is also referred to in this decision. And the law has been very succinctly explained. With these judgments, there are many other judgments which we can go on enlisting and discussing. However, the time would not permit all that.
I'm just checking it out as to whether we have.
I would therefore say that there cannot be a conclusion to such kind of discussions. We can feel that we have acquired a little mileage in understanding as to in what direction we can focus our energy and go ahead to learn more about these aspects of law. since I've consumed more time than what is required, I would like to conclude here and request all of you to pardon me in not coming up to all the coming up with all the required judgments and everything because of paucity of time. I would only request all of you to make further studies in this, and
Once,
thank you, Vikas.
once as a student of law or as a lawyer, if you have a route to be navigated, then automatically you start finding more of the judgments. Once you have given the important facets to be understood, coupled with the important judgments. And those who want, we will try to post this PPT on our website. You can watch that, and with tandem with this talk given by Mr. Deshpande, I'm quite sacrosanct that people will actually cherish it. Everyone stay safe, stay blessed. Namaskar.